Joe Biden and his friends in the anti-gun community love to talk about so-called weapons of war and how they're not protected by the Second Amendment's right to keep and bear arms. But is this true? Well, it turns out that in the Nysurpa versus Bruen case last week, the Supreme Court seems to be saying that no, just because something is a so-called weapon of war doesn't mean it's not protected by the Second Amendment. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, constitutional attorney, best-selling author, and most importantly, proud American gun owner. If you haven't subscribed to the channel, Four Boxes Diner, please do so and show your love for the Second Amendment like we love it here. How many times have we heard things like out of Joe Biden's mouth, in fact, just most recently, things like, hey, weapons of war are not protected by the Constitution. There's no role for weapons of war on American streets. There's no reason for weapons of war to be held by American civilians. Well, that's a great soundbite for the anti-gunners that will have that propaganda phrase repeated over and over and over in the legacy media. But guess what? That argument just suffered a fatal blow, in my view, by the Supreme Court's decision in Nysurpa versus Bruen. Why is that? Because in the decision itself, and this is why you tune into this channel to get this kind of detailed, geeky information, in the decision itself, the U.S. Supreme Court, in upholding your right and my right to carry guns outside the home for self-defense, and the right to bear arms means to carry guns outside the home. Guess what the Supreme Court did? They used no fewer than 3 separate historical examples in American history of American civilians using military firearms as part of their right to carry under the Second Amendment. Why is this important? Because you know and I know that one of the ways the anti-gun community is trying to get rid of AR-15s is they're trying to label them weapons of war, which as we know is not true because AR-15s are semi-automatic rifles, not to be confused with a fully automatic or select fire M16, completely different. We understand that. The anti-gunners either don't understand this, or they don't want to understand this, or they pretend not to know. Any of the above is certainly quite possible. Regardless of that, here's the reality of it. The Supreme Court has essentially, in the Bruen case, reaffirmed what's called the common use test, which is very good for gun owners, and that is if people in the United States, if Americans are commonly use a particular type of arm for lawful purposes, then it's protected. So the Supreme Court in Bruen cites favorably to Caetano, which says that firearms or weapons that are commonly owned by Americans for lawful purposes are protected Second Amendment arms. That's very good news. But let's go beyond that. The Supreme Court actually went beyond that, in my view, in supporting what ultimately will be striking down so-called AR-15 bans or assault weapon bans. Why is that? Because in the context of their opinion, they used 3 different examples to show how Americans used military-style weapons to exercise their right to keep and bear arms. Let me give you the examples, all of which is not me. This is what the U.S. Supreme Court actually said in the Bruen case as part of the majority opinion. First of all, the Supreme Court pointed out in 1871 and in 1872, the state of Tennessee had codified a rule that says you couldn't carry handguns except you were allowed to carry openly. And what were you allowed to carry openly? You were allowed to carry openly a United States Army pistol or similar weapon. And if you were allowed to carry it openly in Tennessee, and the Supreme Court in Bruen says, hey, there you go. You're allowed to carry an Army pistol openly in Tennessee in 1871 and 1872 as part of your right to bear arms. Then Justice Thomas, as you know, Justice Clarence Thomas wrote the majority opinion in Bruen. Then what Justice Thomas wrote about was post-Civil War activities in the South. Specifically, Justice Thomas talked about the sorts of firearms that African Americans that wanted to protect themselves in late 19th century America, what would they use? What did they have to protect themselves? Because as you know, there was still a lot of hostility from Southern politicians, former Confederates. They weren't big fans of African Americans, having free, anything, any free constitutional rights, including the right to bear arms. So what did those African Americans use? Well, Clarence Thomas talked about it in the Bruen decision, and he specifically said that the blacks had procured a great many of old Army muskets. That's what Clarence Thomas wrote. Old Army muskets is what the African Americans procured in the late 19th century to protect themselves against people that were trying to hurt them and kill them. And this was also discussed, as Clarence Thomas points out, as part of his discussion involving the Freeman's Bureau, which we should do a whole segment on at some point. But the Freeman's Bureau was set up by Washington, D.C. to try to help the former slaves get their full-blown civil rights. And one of the critical civil rights, as Clarence Thomas explained, that the freed slaves wanted to have and needed to have was the right to keep and to bear arms. And finally, again, this is not me, this is what the Supreme Court said. And finally, the Supreme Court in Bruen specifically says in 1881, the state of Arkansas had banned the carrying of concealed pistols, but had exempted pistols that were used either by the Army or the Navy of the United States. So what does this mean? It means that the Supreme Court, again, talking about how you had a right to carry guns openly in Arkansas in the late 19th century, perfectly fine if you were using a pistol that was a U.S. Army pistol or a Navy pistol. Again, this confluence, this overlap between civilian firearms and military firearms. Now, we know that this is not unusual in American history. But what's particularly significant is that the Bruen case was so dependent upon American history and the American history of firearms and how Americans used firearms, including our self-defense gun culture, that the fact that the Supreme Court felt comfortable talking about these military-grade weapons being used by American civilians in these various contexts to justify the Supreme Court's ultimate decision that we have a right to bear arms, carry guns outside the home for the purpose of self-defense, I think is a very good news for future litigations involving AR-15 or so-called assault weapon bans. It's pretty clear that the Supreme Court in Bruen was uninterested in this distinction between military firearms and civilian small arms. They didn't seem particularly interested in this at all. And now this should not be surprising because, of course, the history of the United States shows there is tremendous overlap often between, weapons used or firearms used by the military and firearms used by the civilians. It goes back and forth. In fact, it goes all the way back to the start of our country, where to serve in the militia, Americans would bring those weapons and their ammunition and their black powder and whatnot that they used at home, and they would bring those commonly owned weapons that they used at home to militia service. So thus, to have an effective militia, you need to have an armed population so that the armed population could have their own guns privately, but then they would bring those to militia service to help to protect the society, to protect the country, to protect their communities, and of course to protect themselves, as we've talked about in other videos. Now, there's many other examples in American history where there's overlap between military small arms and civilian small arms. Just give you an example. We obviously know it from the American Revolution, to some degree in the War of 1812. We also know that there were Walker Colts, for example, that were used by the U.S. Army in the Mexican War. Slightly improved versions of that, I think, were made available in the civilian market at the time. And I'll give you a few other lists here that I jotted down. In 1851, the Navy revolver, and in 1860, the Army revolver were both used in the Civil War, but these were also very popular for civilians in the United States. The muskets used in the Civil War were also widely used by civilians, as we just talked about, by freed slaves used these old Army muskets in the South to protect themselves after the Civil War. We know that in 1873, you had something called a single-action Army Colt revolver. This was the most popular gun, of course, among civilians in the West. I'm sure you all know this. In 1903, there was a Springfield bolt-action rifle. It was the main battle rifle used by the United States military in World War I. That was back then used, the Great War. And, of course, that weapon was also owned by civilians in huge numbers, by the way. We know the Colt 1911, of course, the famous Colt 1911, a semi-automatic pistol. That was standard service firearm both in World War I, World War II, and also the Korean War, as well as Vietnam. And, of course, we know many, many, many millions of Americans have owned these over the years, even though they serve dual purposes. So I think it's very important that the U.S. Supreme Court itself, not me, not you, not some gun guy somewhere in America, not a scholar, but the U.S. Supreme Court itself literally used several examples, to show that military-grade weapons were actually used by American civilians, and the Supreme Court did it in the context of deciding that you and I have a right to carry guns outside the home, because that's what the right to bear arms means. Again, the right to keep means the right to have, to possess. The right to bear means the right to carry. That's what the Supreme Court said, and the Supreme Court used these military-style weapons and examples in American history of civilians using these weapons, and I think this bodes very well for the future, or lack of future, of AR-15 assault weapon style bans, because I think the Supreme Court has seen through the facade that the anti-gunners like to advance, which is that military-grade weapons or assault weapons or weapons of war are somehow not protected by the Second Amendment. The reality is we know all those phrases are nothing more than propaganda terms. They have no real meaning. If you walked into a gun store and asked for an assault weapon, they would think you were nuts. And, of course, the anti-gunners either don't know it or they don't care. Okay, well, I hope you learned a little bit something more here today at the Four Boxes Diner. If you haven't subscribed, please do so, and make sure you share this video with other people. We're working hard to try to get these videos distributed to more people. And again, we really appreciate your time here at the Four Boxes Diner. And again, we'll see you soon. Four Boxes Diner time.
Orders up. Table 2A.